The tribunal comes to the following conclusions based on its factual conclusions spelled out above and on the basis of legal opinions and advice received. As to genocide, the tribunal has no doubt whatsoever that physical acts have been carried out that are indicative of the crime of genocide. Reviewing the definition of genocide found in the Genocide Convention and repeated in what's called the Rome Statute of the International Criminal Court, the tribunal is certain that there's been killing of members of a group, there's been caused serious bodily or mental harm to members of a group, that there's been deliberate inflicting on the group of conditions of life calculated to bring about the group's physical destruction in whole or in part. And the tribunal also finds, in relation to the legal understanding of that term group, that both the Falun Gong and the Uyghurs do constitute respectively a group. Further, they belong to one or more of the groups that are specifically identified in the Genocide Convention as deserving of protection, namely a national, ethnical, racial, or religious group. In order to find criminality, there must be a conjunction of both physical acts and mental intent. The question to be asked by the tribunal is whether the crime of genocide has been committed by way of forced organ harvesting of prisoners of conscience. And to arrive at that conclusion, the conclusion that a crime of genocide has been committed, such forced organ harvesting must have been carried out with the specific intent to destroy in whole or in part those groups. The tribunal has not been able to find the requisite specific intent. The tribunal notes, of course, the intention of eliminating the Falun Gong as enunciated by General Secretary Jiang Zemin to the Political Bureau of the Central Committee of the Communist Party in June 1999, the 20th anniversary of which has just passed. Separately, the tribunal notes the development of the market for organ transplant surgery with its huge money-making potential. How and when these two separate lines of events met and merged is not clear from the information and evidence available to the tribunal. And this, in turn, led to the tribunal being unable to conclude with certainty so as to be sure of the very specific intent behind forced organ harvesting of prisoners of conscience. And what concerned the tribunal, in part, was the fact that some practitioners of Falun Gong and some Uyghurs who, while having suffered arrest and detention, were nonetheless released, notwithstanding that they made, with respect to Falun Gong, no promise nor given an undertaking to cease the practice of Falun Gong. Sometimes repeated arrest and detention. Why so? Why was this allowed to happen if the physical and biological extermination of the Falun Gong or of the Uyghurs was the ultimate goal of the Communist Party, or the PRC, their release should not have occurred. If, however, the goal was primarily organ harvesting for profit, then different considerations might apply. And as cautioned by lawyer Datuk Sivananthan, the intention to forcefully harvest the organs for sale for sake of profit is not the same as an intention to forcefully harvest the organs to bring about the physical or biological destruction in part of a whole or a protected group. Given that there were no participation of representatives of the PRC or the CCP, the Communist Party, in these hearings to address this issue, and given that no evidence, explanation has been offered to otherwise account for the release of persons detained, the tribunal is constrained thus from concluding that the crime of genocide had occurred. An alternative argument that was considered by the tribunal was that it was not necessary for the determination of the crime of genocide that some of the Falun Gong and Uyghurs were or were not released and or allowed to leave the PRC, given that the definition of genocide only required that acts of genocide were carried out with intention to destroy a group in part, not in whole. Well, the tribunal noted it was possible to characterize what had occurred as the implementation of a policy to develop the market for organ transplant, where Falun Gong and Uyghurs served, unfortunately, as a ready and rich resource to meet that demand, such that infliction of forced organ harvesting on these groups was not primarily motivated by the intention to exterminate them. Whether or not, despite that, those responsible for the harvesting, forced organ harvesting, had the requisite mental state or intent to constitute the crime of genocide is not clear. and whether what's called a knowledge-based approach to criminal intent to commit genocide could be attributed to them is also unclear, and as advised by Mr. Sivananthan, fraught with legal uncertainty.